Hi, sir. Glad
Mm.
to have you with us. And
So,
we're trying to decode latest provisions pertaining to equalization levy or digital services tax in the budget 2021-22, and why it has rattled the industry. In fact, we are hearing that many businesses are planning to move court over the clarifications proposed in the budget on the 2% levy on foreign digital operators, which seems which appears to have significantly expanded the scope of the tax. You played a key role in India's efforts to bring non-resident digital economy firms into the tax net, essentially the ones that have a large market in India, like Netflix, Google, Facebook, and Amazon, to say the least. But they end up not paying taxes at all to the government of India in line with the traditional, or at least as much as they earn out of India, which is in line with the traditional international tax system, which requires having physical presence in a jurisdiction. Now, since you were instrumental in introduction of equalization levy in 2016, which started with a 6% tax on digital advertisement, it will be interesting to understand from you the objective of equalization levy and why is it needed.
okay. Well, as I said, I mean, the new business models which have started emerging with the last 8 to 10 years have brought to light that the international tax rules which are prevailing are not really adequate in allocating the income across jurisdictions, because these international rules depend upon physical presence in order to allocate business income, and the transfer pricing regulations of the rules believe in arm's length comparisons, arm's length standards. Both of these concepts are failing when we come to the new models, because in this digital age, you can do a lot of activity, a lot of business in a jurisdiction without having a physical presence. And secondly, the heavy reliance on intangibles, a lot of intangibles created all the time, which are not properly valued by the current transfer pricing rules. So there has to be some other way of allocating income amongst jurisdictions. Now, equalization levy was a measure was to say that, look, an enterprise which is doing business in my country is not paying any tax, but a domestic enterprise doing the same activity in my country is paying a substantial amount of tax. So there has to be a levy which sort of brings them on a level playing field, and that's the genesis of the word equalization levy, and that's what we did on, even though there was no consensus in the world on how to tax these economies or these transactions, but we still went ahead with our policy statement, really, to say that we tax them.
Right. So while the 2% levy on e-commerce operators was introduced in the Finance Act last year, the budget this year has broadened the scope significantly. The levy would even cover brick and mortar businesses that have an e-commerce model, like hotels and airlines. Then it will cover payment gateways, software companies, e-commerce operators, and even people selling any goods on these platforms will fall under the purview. But is it fair to the industry, because of these clarifications seem to have come too late, with deadline for 3 quarters already gone by?
Well, I personally don't think that what is proposed in this finance bill represents a considerable expansion in scope. I think that the scope of the levy as enacted last year itself was huge. It was very, very wide. When you talk of e-commerce supply of goods or provision of services using a digital facility or a platform, it's a very wide thing which can capture almost every type of digital transaction, including sale of goods. So and that I think it's not just that something has been done in this budget or in this financial year to expand the scope. I think this budget provisions are really intended more to make the levy more clear and try and plug some gaps in the legislation. But yes, it was very wide in the first place. Now, as far as fairness is concerned, yes, of course, well, there's nothing very equitable about a tax. But then it will cause some issues and some compliance problems for taxpayers. Having come at this late stage when 3 quarters of the year, as you said, have already gone by. So yes, they'll have to do a lot of adjustments in their own systems and try and comply with this newly clarified law. To that extent, yes, it does require more compliance, but then, as I said, one can't have a fair tax all the time.
Right. So, does this mean government should have issued FAQs last year itself? Because, like, government is also claiming that these are only clarificatory in nature, and this was always our intent to tax all these transactions.
Yes, of course. I think still have not been able to understand why the government did not come out with clarifications last year. This levy, as I said, was so broad or so wide in scope in 2020 when it came all of a sudden at the time of the passing of the finance bill. There was no debate, there was no discussion in the public domain on the scope of this levy, and it came all of a sudden in the end of March, being effective from the 1st of April. So I think it really called for a number of clarifications to clarify the scope, clarify the intent, clarify how it is to be computed, how it is to be paid. There are a whole lot of questions out there. The section itself, which came into the Income Tax Act, had a provision saying that the CBDT may issue guidelines. I mean, there are very few such provisions in the Act. It said that the CBDT can issue these guidelines, and these guidelines can be placed before Parliament, and they will have the force of law. So it was envisaged that there'll be a complexity in this new law, and that people will demand clarity. And then to turn around and say that no, it doesn't need any clarification was something very, very strange. On the other hand, by not issuing FAQs or clarifications, I think the government did a disservice to itself, because then people started making their own interpretations,
Yeah.
and obviously those interpretations would be directed at trying to see how best they can come out to the scope of the levy.
Right. Right.
Um, so, for example, they said that look, if I'm providing a service which is in physical space, for example, a hotel is providing a physical service of lodging and boarding, then it doesn't matter if the hotel room is booked online. Provision of service is not online, therefore I'm not covered. It is these sort of interpretations, in fact, which have given rise to these proposals in the current finance bill, trying to clarify that no, I mean, as long as any, in fact, the drafting of this new provision is was very strange. But what I think it means is that if any of these elements are there, online booking, online acceptance of sale, or an online purchase offer, then it doesn't matter whether the actual provision of service is offline or online, or it will be covered. That's what it wanted to say. So yes, I mean, I think because the government did not issue clarifications, there was a lot of differing interpretations by taxpayers, and I think the government lost out as a whole, because one didn't see that increase in taxes or tax receipts which one would have hoped for. Obviously, people are not paying; they were not sure of what was the levy.
Right. And like you're talking about interpretation, how people have interpreted it. Now, with the clarification, also, people are making various sorts of interpretations. One is a very interesting one that I came across, that uh, so if an order is placed, say, for example, uh, a Mercedes-Benz dealer in India places an order with Mercedes in Germany, or an email, that may also come under the purview of equalization levy. However, if it's placed via telephone, then it will escape the levy. Is that correct? I mean, or is it going too far with? Uh, inter
Um, no,
integration.
but I think yeah, I think that's going a bit too far. But then I don't blame people for saying that, because the language that has been used in this current draft proposal in the finance bill is very vague. It doesn't give out the right impression. And now uh, this direct sales or sales by companies using a facility or using a platform or some digital facility is covered. That's what the language
Right.
was originally said. But by merely sending an email does not mean that there is a digital facility or a platform in existence somewhere. There may not be any such platform anywhere. Um, so how it can't be covered? That can't be the intention. But when you write
But sir,
in the
it
language
says
of the
that.
law that includes, yeah, it says,
But sir, but it says
yeah,
that, but it says that when any of the following activities take place online, and it says placing the purchase order. So that's why I think, or acceptance of the purchase order, and it says
yes, I agree. I
online.
agree. As I sort of said, yeah, yeah. I agree that the language that has been used out there that does give this impression, and I don't think that this is the intention at all. This is not the intention, because uh, the basic thing, the section starts with by saying that there has to be a digital service, a digital facility, or a platform. Now, now supposing if there is a, for example, if the same Mercedes Benz car was hosting a website, and which was available all over, and people could interact with that website and place orders, then maybe that is something which could was covered in the levy. But by merely sending an email, that doesn't mean really anything. Absolutely. So it should not be. It's not a. It doesn't extend to that level. But the language is unfortunate. Yes.
All right. And and another concern is pertaining to uh, online hotel or travel booking. Like I think you mentioned just recently that uh, so if you book in, so say booking.com, another major concern is that if online hotel or travel booking is via a portal based out of the country, the servers are based out of the country, but the hotel is in the country, and the service is being used by an Indian. So will that also be covered here? And another concern is with respect to gross consideration. Will full booking amount of the hotel, or full uh, booking, yeah, full uh, booking amount will be charged equalization levy
Yeah.
to the portal?
Now, two things that you have
Yes.
pointed out here.
Right.
Now, on the first part, uh, by hotel saying that no, it is actually providing a service in physical space or offline. No, that I don't think that is interpretation is correct, um, because when the booking is confirmed on the platform, the service is provided using a digital facility or platform. I think, I mean, you can say that, all right, no, no, the payment has been made separately, or that the room was always there in physical domain, and all these services actually are provided physically and not in any online manner. But the fact is that when you talk of e-commerce, we're talking about what has when has the transaction been completed, and for that, I think that once a booking has been done on the platform, and an assurance given that now I will make the payment, then that is a contract in the new e-commerce sense. I mean, that's a difference between the new world and the old brick and mortar economy. where brick and mortar, the contract had to be in writing, it had to have a place, it has to have a local standard. Now, here in this computer world, you only click somewhere. If you click an advertisement, that means you have now contracted to pay for that advertisement.
Right.
I mean, so
Right.
it's a whole new world. So when you do a booking online, and you are then saying that yes, I'm now going to make a payment for it, then there is a contract entered into, and the transaction is completed. So I don't. This interpretation is not correct, that the services are offline and they should not be covered. And that's what the amendment proposed this year wants to clarify, actually, that if you have accepted the offer on the platform, then it is covered. The second part is absolutely justified. What you're saying, in many such cases, when the payment is made by the customer to the e-commerce operator, then the e-commerce operator is obviously an intermediary,
Yeah.
and therefore, I mean, he is not earning that whole amount of income. I mean, that he's passing on the major part of what he receives to the service provider,
Correct.
and therefore, he should not be taxed on the gross amount. And that's a problem. There's a problem with the design of the Indian law. Uh, uh, Probably one of the issues, I mean, because it has been brought in such a hurry. I think we did not really think too much about the design. There is a design flaw in the sense that it should always have been the service, the digital service, which can include an intermediation service.
Right.
So when you say platform or facility, it is providing a service to
Right.
both, to the customer and to the seller, and brings them together on the platform. So that service is what it should be taxed. That's what is happening on online. And obviously, then you can't tax that service by a amount which is just passing through. Though, so that's a design fault, I would say, and I hope that some change Maya should come about in the law to clarify that point, because it should never be on the gross consideration.
So you mean to say that uh, as far as portals or marketplaces are concerned, the tax should ideally be on the commission part and not the entire gross consideration, because that's not what they will get ultimately.
That's right. That's
But
right. So
but
probably, what has happened is, when we brought in the 2016 equalization levy, there was a flat percentage, but there was a logic on that, because the scope of what was being taxed was very narrow. It was just digital advertising services, something which can be defined very easily. Something one can say that, okay, you can estimate a certain profit percentage on these services. So you apply one rate of withholding or reduction on that, and it can still be justified as taking into account the income component of that transaction. But here, uh, obviously, when there is intermediation service, one is not taking into account the income component of the transaction. One is then treating it to be a transaction tax, and that's a design problem. I mean, this is not meant to be a transaction tax. It is meant to be a direct tax, and therefore must talk about income. And that's why we have so much of criticism on it as to the nature of that tax. So I think it should always have been. I mean, intermediation has to be on a net basis, and in fact, for each category of service or supply, there has to be made. There could be a calibrated levy, which can be calculated in such a way that it becomes an income tax, a tax on income rather than a transaction tax.
Sir, but in the post-budget interactions, similar questions were asked to the government, but they have said the intent was always to tax these services on gross consideration basis. So, are we moving towards a non-adversarial tax regime? Because the government is not doesn't seem to be willing to listen, and this has led to even more confusion and uh, difficulties for the industry.
Well, yes, I think that's unfortunate. As I said, the fact that they did not issue clarification last year was unfortunate. And this year, if you just stick to what we intended and all, and refuse to consider practical and needed changes in the law, then yes, it will be quite unfortunate. Um, it more than non-adversarial. I mean, I would say that it goes against the avowed principle of tax certainty. We have heard the finance minister herself talking about now, after the budget, that the principal objectives of the government is to provide tax certainty, and that the higher revenues will come from better compliance, better tax certainty, better resolution of disputes. That is what she is on record as having said, and that's correct. That's good tax policy. But then, on the one hand, if you say that tax certainty is very important, and on the other hand, we do not clarify the law, we enact a legislation which is so difficult to comply with, then it's talking at cross purposes. Really, it's not in line with what the mature tax policy should be. So I don't know. I really hope that better sense will prevail, and that there will be some changes in the design. At least, it may not be possible to change the whole law which was brought in last year, but then, every legislation in every country wherever they have enacted has some exclusions. You can carve out things. So there are clearly these problems, as you mentioned, of gross taxation, which in I think we can carve out those instances and see that the law doesn't have unintended effects.
In a way, is our scope, if you compare our equalization levy with uh, the digital services tax of as imposed by or as introduced by a lot of European countries, including France, is our scope the widest?
Well, I think so. Yes, I think it is the way it is, because we have included supply of goods or sale of goods. That I don't think has been included anywhere. The other legislations are all on a sort of DSTs, or digital services tax, and that's what I had earlier mentioned. This should have been a tax on services, not on the sale of goods. So by expanding it to the sale of goods, yes, it becomes very, very wide, and then there is no distinction between business to consumer, or business to business. It's all covered somewhere. So it's a very, very wide scope, and without really adhering to the principle involved. It's not found anywhere else in the world. And then this, obviously, when you when you have such a levy, and you still want to design it in a manner that is simple to administer by a single withholding mechanism on the gross receipts, then one is not sure of the nature of the tax. As I said, it then becomes a transaction tax rather than anything else.
Okay. So another issue pertains to double taxation. I think you touched upon the topic, but again, the case where a local buyer and a seller transact over a foreign e-commerce platform, uh, would this amount to double taxation, and does this also needs correction?
Yes, so one situation is very clear, where the seller is and the purchaser are both residents, and they're just going through a platform which is run by a non-resident. Now, if you are levying tax on the whole amount of consideration going to the e-commerce operator, you're taxing that whole transaction at one stage, and then when the seller receives the amount from the e-commerce operator, he pays normal corporate tax or normal income tax on his own. So the same income is getting taxed twice. There is clear double taxation into that to that extent, and that at least is something which I think, as I said, the government must clarify. And this problem is coming up only because we have not spoken of intermediation services. We have just said a supply of goods and services from the platform.
Hmm.
So there is that design problem, in the levy, which is giving rise to this shit. But yes, now itself we can think of carving out exceptions, bringing out, taking out these cases where there is obvious double taxation. This is the least that I would expect the government to do.
So, and in fact, you led the panel that recommended equalization levy back in 2016, where you recommended, the levy ranging between 6 and 8% on a host of online services. Uh, so, has the government gone beyond what was the original intent?
Yes, and it had because we never spoke about online sales and sale of goods. We also said that we should start with one service or advertising. Although we had listed out a number of services in our report, which could in future, as we gain experience, it could also be subjected to that levy. But what we wanted to say, that was it was a time when no other country had brought in any such levy, and India was the first. So India was actually making a political statement. It was making its statement very clear that we believe that this income must be taxed in the market jurisdictions, and that if global consensus does not allow that taxation, then India will enact its own law as a
Right.
unilateral measure. So it was a more of a policy statement. You would recall that the tax collections from that levy were hardly anything,
Correct.
and maybe a 300 or 500 or 800 crores. I mean, that's nothing much compared to the overall budget collection that we have. But then the importance was that India's position was made very clear, and the second importance was that more and more countries then also jumped onto the bandwagon and said uh, that if there is no consensus, we will have our own unilateral measures. So it was an entirely different context in which that levy came in. So one can't really compare that. This 2020 levy is, as I said, very, very wide in scope. This was not envisaged in our report.
Right. And so, what are the sort of queries that you have come across from the industry or elsewhere uh, on the budget provision?
Okay.
So,
No, the queries are are just this, that that just because because there is a purchase order which is online somewhere in some form, so is it covered? Or more serious is the thing that if there is a payment online, and everything else is physical, then is it still covered? And that will really take the levy to some extremes, and completely unintended, I think. So if you go only by the payment of consideration, that's one of the factors mentioned in that section that is proposed in the finance bill. So these are the queries in which I frankly I when I'm asked, I have no answer, because I mean the language as written in the finance bill does seem to say so. I can only then tell people that, look, I mean, this can't be intended, or this does not appear to be the correct intent, and that it is not in accordance with the principle of digital taxation.
great, sir. And lastly, as we are hearing from different quarters that they're going to challenge the the equalization levy uh, bit in the court, filed a writ petition. So, on what grounds can it be challenged?
Well, I'm hearing, yes, I know that some very eminent legal minds have been talking about it. I have interacted with them on public platforms and disagreed with them entirely. So the challenge is on the ground that firstly it is unconstitutional, in the sense that the constitutional lists do not allow the union government to levy such a tax, and it is in the nature of an indirect tax, or a sales tax or something, or transaction tax, which is not within the domain. And second challenge is on the ground of extraterritoriality, that it is going beyond the jurisdiction of India. So, well, I don't agree with either of these points, of course, because the levy has been brought in under a particular entry in the concurrent list of the Constitution. That list does give the union government sweeping powers to levy taxes on any items which are not covered in the state list. So this was what had been done in the 2016 equalization levy. This was the rationale for the securities transaction tax. This is something which has all along been accepted. So I don't see why it is now suddenly becoming non-acceptable. It is there has been no challenge as yet on this ground. On the issue of extraterritorial, well, again, I think people are missing out on the whole point of the levy. The whole point is that a country's right to tax arises when there is business carried out within its territory. There is something happening inside its economy, and value is being created in that country. Then the country certainly has a right to tax, and nobody can deny this principle. If people are confusing it with the permanent establishment concept of tax treaties, that is different. That is a matter of treaty interpretation. But a country's right to tax is always extends to situations where there is activity inside the country which is giving rise to income and which is creating value. And on both these counts, I think the type of transactions that are taking place in the digital economy are 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 creating value because of the user contribution, the data that is collected and used, and it is giving rise to income. And therefore, I think there can be no doubt at all on the ability of countries or the authority of countries to levy such a tax. The treaties don't allow it. That's a separate problem. That is what is being tried. We are trying to resolve in the inclusive framework by bringing in new international tax rules, which can modify the concepts and allow the such taxation. So, but on principle, there is nothing extraterritorial about
Great. Thank you so much, sir. It was insightful hearing your perspective on a very controversial topic. Thanks a lot. Thank you so much, sir.
it. Right. Right. Thank you
Yes.
very much.
Yeah.
Bye.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.